Tonight, the Supreme Court enters yet another first after failing to raise enough judges to sit in a petition that could have determined whether Thursday's election was legal or had legal backing.
The hearing failed to kick off after only 2 out of the 7 judges turned up for work.
Chief Justice David Maraga offered explanations for the quorum hitch, but Ken Mijungu reports that not all are convinced it was inevitable.
At exactly 11 a.m., 30 minutes after the Supreme Court had indicated it will be in session, a solo judge walks into the courtroom, packed with lawyers and interested parties. Justice David Maraga took his seat and the suspense in court was palpable. He then delivered in a minute and a half the challenge that will now go down in the books of history as a first.
Regrettably, and with due apologies to all the parties, this matter cannot proceed to hearing this morning as earlier scheduled for the following reasons. Following the events of last night, which are in the public domain, the Honorable the Deputy Chief Justice and the Deputy President of the court is not in a position to come to court. The Honorable Justice Ibrahim is unwell and is out of the country for treatment. The Honorable Justices Ojwang and Wanjara are not able to come to court. The Honorable Justice Njokindungu is out of Nairobi and has been able to get a flight back to Nairobi in time for the hearing of this matter. That leaves Justice Lenaola and I as the only judges present. As the two of us cannot form a quorum under Article 163(2) of the Constitution, this matter cannot therefore be heard this morning.
The court also indicated that they will hear the petition at a later date, but with the clock ticking, the case that was filed by the 3 voters seeking the Supreme Court to revoke the October 26th election date as gazetted by the IEBC will have been overtaken by events. Halifa, a voter from Nyali constituency, Samuel Mohochi, a voter from Westlands, and Hassan Kamau from Mathare constituency were challenging the Thursday's repeat election. The 3, through their lawyer Harun Ndubi, wanted the Supreme Court to intervene and stop the repeat election.
I think it is important to say that they owe the country, they owe the Constitution, they owe the sovereign people of Kenya an explanation as how they choose to withdraw their labor when they are required to sit. It is not, it's not a favor they are doing this country as judges. They have a duty to sit at all times.
The matter had been certified as urgent and directions issued by the court. It was set to begin today at 10:30 a.m. Lawyers representing the petitioners and the presidential candidates and other interested parties in the case have expressed their dissatisfaction, claiming the lack of quorum is a political mischief instigated by the Jubilee Party.
The resultant effect of what has happened today and probably tomorrow is going to be felt, until, another 10 years. I don't think we're going to recover from what has happened today.
I think I can also read politics into the whole thing. I can read fatigue from Kenyans, including members of the judiciary themselves. I think Kenyans are tired of election and whatever related issues that come out of it, and possibly they really want to go to vote and finalize.
Nobody can assure credibility. How can you assure anything that is in the future? I mean, I'm a research scientist and anything that has not happened cannot be verified. So that kind of talk, biashara zingine kusema, he cannot assure. How can you assure something that you have not done? It is not possible.
This, however, could have not been the first time the Supreme Court will have sat in a case to give directions without meeting the Supreme Court quorum requirements. Lady Justice Njokindungu once sat alone on a bench when the former Deputy Chief Justice Kalpana Rawal sought interim orders to stop her retirement. The orders were only vacated when a properly constituted bench sat and heard the case. The decision by the President of the Supreme Court now leaves the petitioners with one option: to take a new date. If they choose not to, then the case will not proceed. Ken Mijungu, NTV.